Hi everyone, thanks for inviting me here to speak. I'm Andrea Casillas, Director of Linux Defenders Program, which is within the Open Invention Network. So we can have a long discussion about the Open Invention Network, but I'd rather focus on the Linux Defenders Program. So the goal of Linux Defenders is to find ways to protect open source innovation that comes out of the collaborative nature of the community. So our main focus is on patents. So we'll briefly look at the current patent system. So here is the clause that we get, the basis for the U.S. patent system from the U.S. Constitution, Article 1, Section 8, Clause 8, states that Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So there's a bargain here. In exchange for sharing new innovations with society, the government grants inventors a 20-year monopoly to make, use, sell, or import an invention. So the main point is that we want to promote innovation and encourage invention. And so you can see here, this is overall patent allowances across technologies. In theory, we're doing very well in promoting innovation. Yes?
Allowances, please.
Patent allowances, so we're granting patents. And it's steadily increasing.
So does that account for the patents expiring after 20 years?
These are just patent grants. So it's not accounting for the expiration, but in the granting, we're still...
New granting, so it's grantings per year.
Per year,
Right.
yep. And so here, we're doing the same in software patent grants. This is kind of right here covering it up, but this spike right here represents all software patent grants pre-1991. So you'll see that it's fine. It's fine. So pre-1991, oh yeah, there we go. 1991 software patent grants, and then since 1991, it's just increased pretty rapidly for a specific technology. So
Could you overlay those two?
I should do it for the next slide. So obviously, staying in software, we're also seeing an increase in the numbers of lawsuit filings. So why is there so much litigation involved? Could it be that software patent holders are more litigious? Maybe, but there could also be some indications that there are issues involving the quality of the patents granted and overall problems in the patent examination process. So formerly I was director of Peer2Patent, which was a program where we focused on relieving the challenges that the patent examiner faced when reviewing patent applications, and we tried to provide a method to prevent low-quality patents from being issued in the first place. So the Peer2Patent program was actually the precursor to the Linux Defenders program. So really quick, the role of the patent examiner. So they get about 20 hours to evaluate whether the invention deserves a 20-year grant of monopoly rights that will shape the future of an industry and the fundamental research that's associated with it. So in this short time, examiners are expected to digest the potential patent, which we'll get into that a little bit, comply with all the rules in this big, thick book called the NPEP, research prior art, and draft office actions. So keep in mind that these 20 hours are dedicated to the entire examination process. So in practice, this examination process lasts about 3 to 5 years. So 20 hours over 3 to 5 years. So the challenges that the examiner faces. So during the patent review, the patent examiner is constrained by a huge backlog, which some have heard or not, but also the incredibly broad and vague claim language. which I've termed here as patent legalese, because no one really understands it, and a limited access to non-patent literature. So due to these constraints, after all is said and done, the examiner dedicates roughly 7 to 8 hours to actually searching for prior art total. So this means that the patent examiner will be more likely to search patent literature versus trying to track down non-patent literature, which is hugely detrimental to the open source community, because they're not getting an overall understanding of what is actually the state of technology. So here are some examples of what's typically not searched by the Patent Office. So scientific publications, technical reports, conference proceedings, all of this stuff is not because they don't want to search it. It's because they have 7 to 8 hours. They're not going to do a Google search to find where this stuff is. So in light of these challenges, the questionable patents have obviously been issued. And yes, we hear about all the software bad patents, but I mean, and I know that Luis has talked about in his classes, method to swing on a swing. These are stupid patents that have been awarded because of the challenges that the examiner faces. So these challenges were the basis for Peer2Patent. The idea was essentially that through crowdsourcing, those interested in the technology would participate and produce relevant prior art to help the examiner vet patent applications. And just, I'll do some really quick stats. The Peer2Patent program had 2 pilots that lasted for 3 years. For the 300, so it was small, for the 308 applications that actually went through the program, the community submitted close to 1,300 prior art submissions. Well over half of these were non-patent literature. And actually this was the most important part, because we expect that the patent examiner is really well equipped to search patent literature. So the non-patent literature is actually new sources that they wouldn't have previously found. And they were introduced to the patent examiner. And so in all, the patent examiner cited references submitted for Peer2Patent for about 1/3 of the applications that went through the program. And you see, not exactly the amount that we wanted, but these references that were made by the patent examiner, they, in surveying them, they would not have used the same references had they not gone through our program. So even for the patent literature, they wouldn't have made the same rejection without the review of the community. So at the end of the program, just over 100 patents were granted, which is good. I mean, there are several issues. I mean, obviously, this number at the end of the program is still discerning, but that goes into other issues that the patent office faces. But so the overall goal of Peer2Patent was to improve patent quality. And so we were able to show the patent office that crowdsourcing could be used to help address the challenges, or some of them at least, that the patent office and the patent examiners faced. So there were over 40 universities that participated in Peer2Patent. And students accounted for over half of the activity, including prior art submissions, discussion, review, research, and over half of the submissions that were cited by the patent examiners. That's pretty notable, because these are either law school students or undergrad students. That law school students may not have the computer background that we're necessarily looking for, and undergrads, I mean, they're still working and developing within their education. So it's pretty notable that all these students participated willingly. Oh no, sorry, this is not labeled, but this is actually the litigation threatened by non-patent entities. Sorry, forgot the label here, but non-patent entities, or patent assertion entities, or trolls as they're called, have been steadily increasing. We're seeing more and more. And we're finding that crowdsourcing the prior art isn't enough. There are more issues that need to be resolved here. So with the amount of assertion that have been going on from non-practicing entities, we are seeing an increase in startups and individual inventors with the amount of fear, uncertainty, doubt, or the FUD that's associated with open source. And so this chart kind of exemplifies, had I better labeled it, sorry. So we talked about the method of swinging on a swing. And that was a silly patent that got awarded. But when we do have a problem with patents when they threaten innovation because it's counter to what the whole goal of the patent system was. So here's an example of a patent, a Microsoft FAT patent, that actually threatened innovation. And I'm going to go through it really quick, hopefully a quick timeline just to Oh, man. Yeah. Hopefully it goes. And live demos.
It looks like it's loading.
Yes. It's loading. It's getting there.
It's Prezi.
Yeah. Yeah. So much more fun to look at.
I've never used it. One of my students used it as a presentation. It's cool.
Yeah, it's fun to put together.
They say it's not that difficult.
Not really. As soon as you get the hang of it, you just need to have the overall picture in your mind.
Yeah. And then
Sorry, guys. I'll give it one more second, then we can move on. No, so Peer to Patent actually it was a program in cooperation with the U.S. Patent Office, and it was a pilot program to see whether crowdsourcing and the public would participate. So crowdsourcing worked and the public would participate. So with the new American Invents Act, the Patent Office actually incorporated part of the program at least. Not the collaborative nature, but the third-party submission system. So I'll quickly go through this.
Are you using this example because of some of the recent exchanges that have been made between the evil empire and various companies over smartphones?
Yeah. I like to show that it's crazy out there.
Just a little bit.
So we'll start out with these FAT patents that were awarded to Microsoft. And it's these four, well, five. One is the European patent. And so I don't know if everyone knows about this. I did not know too much about this prior to getting involved here. But the file allocation table patent wasn't considered inventive when it was awarded. People were using it already. There just wasn't a way to show that people were using it because it was already out there. People didn't even think it was invented. They're not going to patent it. There's already some anger that something like this would be awarded anyways, but nobody really paid attention. Until December 03, when Microsoft announced that they are going to incorporate it into their licensing portfolio. So here are the terms. Nice way to make some money. But now the community's pissed. So they, in 04, this PubPat, which operates outside of or inside of New York City, they kind of go after these bad patents, filed a request to revoke this, citing prior art. They actually found the prior art and they gave it to the patent office to review, stuff that the examiner hadn't previously seen. And as you can see, Microsoft is using its control over the interchange of digital media to aid its ongoing efforts to deter competition from free and open source software. So in 04, the USPTO rejected one of the patents based on the prior art. So everyone started cheering and patting themselves on the back. In 05, there was a second rejection, another preliminary rejection on a different patent, but same kind of technology. And this time, the USPTO didn't use the references that were given by PubPat. They actually based it on technical discrepancies, such as the correct inventor wasn't cited. Something that you can easily pay for and get amended. So in 06, the USPTO reinstated these patents. So here we go in 09. Microsoft begins their lawsuit spree. So they launched a lawsuit against TomTom based on these bad patents. And so obviously now we're starting to get into what we were all afraid of. Then, even worse, they're starting to settle. So they agree to pay Microsoft money and remove the functionality covered by the bad patents. And here we go with Motorola. And so now the Microsoft is filing in the ITC because they can get a quicker decision in addition to the federal court. So they're taking kind of a two-pronged approach to their lawsuits. And so a really quick overview. For remedy, I mean, there are two determinations that are made. One that's initial, and then this decision is reviewed, and the review decision will be considered final. So initially, the ITC makes a determination that Motorola violates these fat patents. So then we have a posting that Linus Torvalds makes that predated these patents by about 3 years. And here it is. Very simple, not much to it because, again, people don't think this is a very inventive thing. But this is what was sent to the ITC judge to look at. So in March 2012, the ITC invalidates Microsoft fat patent. But it's just the ITC, and it's still going up for review. So now, not to be deterred, Microsoft heads to other people. So here we get one to Barnes & Noble. Again, threatening. And this is what Barnes & Noble says. The patents we read cover only arbitrary, outmoded, and non-essential design features, and yet Microsoft is demanding prohibitively expensive licensing fees. Microsoft is intending to drive open source out of the market. But then they come to a deal for reasons that still are kind of unknown. And I guess we're still waiting to see what happens from this. And Microsoft is still going. There's 15 and counting. HTC, Samsung, plenty of others. And then we start to see the German rulings. So the German judge rules against Motorola, and now Motorola's Android devices are banned from Germany because of these FAT patents. So that's just one example of how this can start threatening innovation. There's arguments to be made about innovative products and innovative patents, and there's different arguments that are made about things that are not promoting innovation in the patent world. So just to reiterate, that was just going to go away. There you go. Thank you. So just to reiterate, with this non-innovative patent, Microsoft is able to flex their muscles and directly threaten open source technologies for something that turns out not to be that innovative. The end result is ongoing. A lot of time and money has been lost. And for the public, we have less options, less innovation, and higher costs for these products. For open source, again, you're under constant threat and fear of being in some kind of litigation. So there are 3 instances where the public can interfere with the patenting process. Before anything is written in defense of publications, during the patent examination, which is now called the pre-grant submission, and afterwards, which are post-issue re-exams. But the longer you wait, the harder and more expensive it becomes to address these patents. So you're given, as an inventor, student, small company, big company, startup, you have 3 options. You can patent everything you create, which the cost to do so is insane, but for those in open source, that's obviously not going to happen. You can ignore patents and hope that no one sues, but we've seen that non-practicing entities, again, are definitely targeting small startups and small individuals or small companies, not for the money that they can make, but for the legal precedents that they can get, or for the more licenses that they can get under the belts. Or you can actively protect your work, and that's what I'm here to talk about, is defensive publications. So this is our merit badge that we give out for defensive publications, by the way. So the FAT patent is a prime example of a bad patent that should have never been granted. There might not have, the more defensive publications that we can publish, the less fear, uncertainty, and doubt that we're hoping to prevent the fear, uncertainty, and doubt that we get with open source. And of course, maybe we can prevent all of these lawsuits. So what is a defensive publication? It's a publication that serves as explicit prior art, ensures your freedom to operate around your design. They're a powerful way to prevent bad software patents from being issued. And they give patent examiner, and this is the most important, they give the patent examiner insight as to the state of technology. So defensive publications allow us to disrupt that balance that was made or intended with creating patents in the Constitution by creating the prior art. So patents are awarded if they're new and not obvious. But if there's prior art, then the patent will not be awarded. And so that's exactly what we're trying to do. So how to write a defensive publication. When I discuss writing defensive publications, people naturally think that they should be or look like patent applications or patents, very vague, very confusing basically, but we don't want that. We actually want something that's easy to understand and doesn't add a lot of work to the patent examiner's already huge load of challenges. So we see, the basics, the title, text, an intro, basically describing how your idea works, what's available, and why you think your idea is better, and figures describing the interactions between the components that you're proposing. It's not necessarily necessary that this be functioning. it's an idea, trying to establish what people think is innovative within the community. So here's an example. And again, it's pretty basic. There's steps, little figures, just getting to the main point, getting to the meat of it. So this isn't a new strategy. Many companies actually incorporate this into their IP strategy. Our focus, as far as Linux Defenders is concerned, is to encourage students and those involved in open source to proactively get their technology in front of the patent examiner. Period Patent showed that the community was able to do that, so we're just extending this idea. And so a little more insight, when to write a defensive publication. Basically, when you're excited and you're going to blog about it. Get it down on paper, and then we'll help you through the process. And how Linux Defenders is involved. So again, our mission is to protect open source from the threats of low quality patents. So we're going to work to get the prior art to the examiner without adding more work through publishing on IP.com. So the process works basically by, we'll work with you to get the publication written. You send it to Linux Defenders, and we'll make any edits or changes that are needed. And after the team, the Linux Defenders team approves, the publication gets posted onto IP.com. IP.com acts as a digital notary, but most importantly, they're a database that the patent examiner actually uses in their search. So we're getting it to the examiner without them having to take any extra steps. And we try to streamline the process as much as possible. That's basically all I have. I didn't want to bog everyone down with patents, but I'm more than happy to answer any questions or anything, any kind of issues. Here's our website if you want to look for more information, linuxdefenders.org.
Yeah, we have time for questions.
As someone who's come from the technology side of the fence rather than the law side of the fence,
Right.
I was a bit disappointed that so many law schools were involved in that two-year project, and I didn't see any engineering schools. Could you?
So we had, Berkeley actually was, they had their entire engineering program participate. And so there were a few schools, and it was there were a smaller amount of schools, but more students that participated. So their whole entire semester project was focused on submitting prior art or finding prior, that kind of help guiding the community and answering questions.
So they brought in as sort of a couple of big engineering departments at the undergrad level.
Right. Yeah, so for the law students, to be in patents, or to be a patent lawyer, you still need to have your science degree. So even though they're law students, some of them did have engineering backgrounds. Actually, a lot of them did. Not everyone came with a life science background that I did.
What was the benefit of taking a broader spectrum of graduate schools would be to further acquaint the students studying science and engineering with the issues with the patent and intellectual property.
Right. So that worked on the definitely, and for the engineers that was really useful. And for the law students, it was useful for them to see, one, to participate in patent examination period, but also to see it from the other side and actually having to search for prior. They also did prior art searches.
So to get them to search for prior art within non-patent literature.
One more question.
Well, we did an RPI last semester, and we're going to teach the common class here soon as well. We're probably going to do that exercise. Will you look at it about it?
So we did an exercise with the students from Luis's class at RPI, and basically he primed them pretty well as far as patents are concerned and open source. So they were already really animated about software patents, which is fun. But then the project was basically to create a defensive publication on the work that you were doing. So they had 2 weeks?
2 weeks.
They had 2 weeks to do it. They did it for an assignment. And we worked together to edit via Google Docs to kind of edit everything out and tease out the most important parts in their defensive publication. And even after the semester was done, I still had students emailing me editing. So it was pretty cool, and they were really into it. So what is nice about the defensive publications is that it's still a publication, so it's still a reference that they can make on their resumes or CVs. And it's something that they can extend what they're learning in school. So not only have they had this open source class and their engineering studies, but now they know a little bit about the IP. It's really important to integrate all of those, I think, now.
So you can come back next semester when Louis is teaching.
Yeah. It's just a train ride away.
Okay, cool.
I'm gonna have a busy semester.
Yeah, I know, right? Okay, great. Thank you so much.
Yeah, you're welcome.